The GDPR is the Global Data Protection Regulation. It was approved back in April 2016 and has been launched today, the 25th of May 2018. It replaces the 1995 Data Protection Directive in the EU, and it's intended to apply broad rights protecting individuals' personal information across the EU. Importantly, the introduction of the GDPR is not a regulation that needs to be enacted at a local member state level. It's enacted European-wide as of today. The GDPR is effectively a complete right of the 1995 Data Protection Directive. It introduces a raft of changes across a broad number of areas. In relation to governance, the regulation now imposes obligations on organisations to appoint a data protection officer physically resident in the EU. The regulation also focuses particularly on the rights of individuals and introduces a number of rights for individuals, including a right to be forgotten, which has raised some interest in Australia, a right to have their data made available to other organisations, or a portability right, amongst a number of other broad rights. Like Australia, the GDPR also introduces a breach notification obligation. The obligation under the GDPR is more stringent and prescriptive, so organisations that are impacted in the EU only have 72 hours to notify of a breach, so it's a lot higher standard than what we're seeing in the Australian mandatory breach laws, which have just been introduced. The GDPR is obviously focused on activities in the EU. However, it's drafted very broadly and is likely to impact organisations outside of the EU, including organisations in Australia. Those organisations that have a physical presence in the EU will clearly be captured. Those organisations that sell goods or services into the EU will also come within the regulation. Even those organisations that use social media or websites to monitor the behaviour of individuals will be captured. Interestingly, a number of Australian organisations that perhaps provide data processing services on behalf of a controller resident in the EU will be subject to the new laws also. The penalties for breaching the GDPR are fairly serious. They're a lot more stringent than those under the Privacy Act in Australia. So organisations that have done the wrong thing in the EU may be subject to fines of up to 20 million euros or 4% of global revenue, which is a huge amount compared to the Australian equivalent. In Australia, under the Privacy Act, individuals can be fined up to $420,000 and organisations up to 2.1. So we're talking chalk and cheese here. Given the stringent obligations imposed under the GDPR, it's important for Australian businesses to be sure that they are actually required to comply. Once you've ticked those boxes, you will need to embark on a systematic review of your personal information handling practices for the EU. So introducing technical and organisational data protection controls within the organisation's a first step. Looking who and where to appoint your data protection officer. Revisiting your breach notification plan. You'll definitely need to update your Australian version to accommodate the 72-hour notification requirement. You'll need to introduce a data breach register into the mix also. Given the importance of consent with the regulation, you'll need to revisit how you obtain consent from individuals in the EU. And you need to look at the type of information you're obtaining. So with the real focus on sensitive information under the regulation, you'll need to decide what information you actually need as an organisation to move forward.